You have the floor, sir.
Mr. President, members of the Court, it is an honor to appear before you today in these historical proceedings on behalf of my country, the Republic of Costa Rica. Costa Rica is firmly convinced that this advisory opinion is of decisive importance for the international community and the future of the planet as a whole. For such a reason, my country played, together with other member states that compose the core group, a leading role in the process aiming at the adoption of the General Assembly's resolution requesting the Court to refer to the obligations of states in respect of climate change. This active role was only natural. Costa Rica has a long-standing and well-known commitment not only to the protection of the environment, including climate change, but also an unwavering support for international law and multilateralism. As the principal judicial organ of the United Nations, the International Court of Justice is uniquely placed to play a vital role in identifying the relevant rules, the rights and obligations of states in respect of climate change, as well as the consequences when such obligations are not met. Mr. President, members of the Court, climate change is already affecting millions of people around the world, especially the most vulnerable communities. Extreme phenomena such as hurricanes, droughts, heat waves, and rising sea levels are causing widespread destruction and suffering. The scientific evidence is clear. Human activity, particularly the excessive emission of greenhouse gases, has accelerated this process, and the effects are felt in every corner of the planet. The damage is not only environmental, but also economic, social, and cultural. What is at stake may well be the survival of human and other species. When addressing climate change, Costa Rica is aware of the paramount importance of this initiative. Although small in size, our country is rich in biodiversity. It is home to around 6% of the world's species and possesses an extensive network of protected areas, including 28 national parks that cover more than a quarter of the country's land area. My country has been a pioneer in sustainability and a world leader in environmental conservation and ecotourism. We have implemented a payments for environmental services program, which has contributed to slowing biodiversity loss, and not only halting deforestation, but actually increasing the country's forest cover to almost 60% of its territory. In addition, Costa Rica is also recognized for producing most of its electricity from renewable energy and committing to achieving the goal of zero net emissions by 2050. Through its policies, the country has set out a long-term sustainable development strategy. It has reinforced its commitment to climate resilience through capacity building and informed decision-making, the inclusion of adaptation criteria in financing and planning instruments, the adaptation of public services, productive systems, and infrastructure, and the implementation of nature-based solutions. Costa Rica has aligned its national policies with international commitments, such as the Paris Agreement and the 2030 Agenda for Sustainable Development, and is party to a number of international agreements, including the Convention on Biological Diversity, the United Nations Framework Convention on Climate Change, the Kyoto Protocol, the United Nations Convention to Combat Desertification, the Vienna Convention for the Protection of the Ozone Layer, and the Ramsar Convention, among many other relevant international instruments. Recently, Costa Rica became the second country to sign the United Nations Convention on the Law of the Sea Framework Agreement on the conservation and sustainable use of marine biological diversity in areas beyond national jurisdiction, known as BBNJ. Thanks to its efforts in favor of environmental preservation and its commitment to ambitious policies, to combat climate change, the country has received several international awards. Costa Rica has also led the way in the ascertainment of a specific human right to a healthy environment at the national and international levels. At the national level, it is enshrined in Article 50 of our Constitution, and at the international level, Costa Rica promoted the adoption of the Human Rights Council Resolution 48/13 of 8 October 2021 and the UN General Assembly Resolution 76/300 of 28 July 2022, both entitled The Human Right to a Clean, Healthy and Sustainable Environment. They are both indeed resolutions, but so is the Universal Declaration of Human Rights. Having in mind that for a small, disarmed democracy like Costa Rica, the existence of an international law system that provides mechanisms for the defense of its interests and effective means to peacefully solving disputes is of utmost importance, in the recent past we have relied several times on this court to resolve our disputes. It is precisely in the context of one of these cases that this court, for the first time in its history, adjudged and granted compensation for environmental damage. In the case, certain activities carried out by Nicaragua in the border area, Costa Rica versus Nicaragua, the court ordered Nicaragua to compensate Costa Rica for the environmental damage it had caused during its illegal occupation of Costa Rican territory. In that instance, the court concluded that it is in line with the principles of international law governing the consequences of internationally wrongful acts, including the principle of full reparation, to assert that compensation is owed for damage caused to the environment. Mr. President, members of the Court, Costa Rica is confident, once again, of the high relevance of this Court's role and has absolute trust in the beneficial impact of the advisory opinion that it will deliver for the future action of the international community to enhance efforts to tackle climate change more effectively. The issuance of an advisory opinion on this matter is not only crucial, but absolutely necessary to ensure a clear and coherent international legal framework to guide the action of states. International law, in its capacity to interrelate global norms and realities, has a central role in building a coordinated and effective response. This advisory opinion on states' obligations in relation to climate change not only will provide a legal answer to two specific questions, but can also set a milestone that inspires unified global action. I thank you for your attention, Mr. President, and I ask you to call on Professor Cohen to continue the presentation on behalf of Costa Rica.
I thank His Excellency Arnoldo Brenes Castro. Je passe maintenant la parole.
And I now give the floor to Professor Marcelo Cohen. Over to you. Thank you, Mr. President, distinguished members of the Court. There is a point where all interveners in this proceedings are fully in agreement. States have the obligation to cooperate to confront the climate emergency, and this cooperation essentially operates via existing treaties. But, and this is a big but, it would be a pitiful exercise in law to stop solely at the Framework Convention to examine the international obligations of states in this regard. The reduction of greenhouse gas emissions is not some simple commitment that states can just feel that it's a good thing to agree to. Financing loss and damage, which has already been caused, always being caused, is not some charitable gesture either. This reduction and this financing find their origin not only in agreements that states see fit to conclude, but also, and above all, in the well-established rules of international law, both substantive and with regard to state responsibility. Now, this is one of the key stakes in your exercise of your advisory jurisdiction. You must affirm that the duty of cooperation does not extinguish the other obligations of general international law. To respond to question A, your task is to identify all relevant primary rules. To answer question B, it is, above all, to identify which conditions allow the application of state responsibility for wrongful acts. Now, I'm briefly going to touch upon these three aspects, and I will conclude in presenting the contributions to Costa Rica to the responses that you have been called upon to give to the questions asked. That will enable me at least to mention other aspects which I believe are equally important. Participants say that you should circumscribe your analysis to what they call lex specialis, but they haven't taken a fundamental question into consideration. Lex specialis derogat legi generali is relevant when you find yourself in a situation where rules collide that are applicable to the same question. Now here there's no question of derogation or of choosing one rule and excluding another. In this case, all rules invoked are relevant and may apply without fear of contradiction and at different levels. Now, that states are in agreement to cooperate in the face of climate change and that they've adopted treaties, well, that's all well and good. But in itself, that neither undermines nor extinguishes the rules of international law which are relevant to the different circumstances produced by GHG emissions. Quite the opposite is true. These treaties have to be interpreted and applied in the light of and within the framework of the legal system as a whole, and not the other way round. Indeed, the UNFCCC, the Kyoto Protocol, the Paris Agreement, the decisions taken at the COPs, and other treaty instruments do not limit the scope of these obligations under general international law. In the advisory opinion of 1996, your court did not stop at the examination of the sole treaty regime applicable to nuclear weapons. Even more reason why, given the questions put to you here, you should examine all the applicable rules. Just to mention one example, the mechanism to implement Article 15 of the Paris Agreement to facilitate compliance with its commitments does not replace rules relative to state responsibility for wrongful acts. For sure, not all participants agree with this, but these disagreements are not about the existence, yea or nay, of a new rule of international law, but on the interpretation and application of rules which already exist. And it is precisely on account of these differing interpretations that your esteemed legal advice is requested by the General Assembly. Let me now swiftly review a number of these rules. First, the duty of due diligence and the obligation to not cause significant transboundary harm. Now, these are obligations of general international law, which you've already recognized and applied, as have other courts. Nothing, but absolutely nothing, prevents the application of these rules to greenhouse gas emissions which produce significant harm to other states and to areas not subject to national jurisdiction. Moreover, The obligation to not cause significant transboundary harm is not an obligation that came into being only when it was first explicitly set down. This obligation derives from the basic principle of international law, namely sovereign equality of states. If they are obliged to respect one another, it is inconceivable to imagine that once upon a time it was permissible for one state to damage the environment of another. And this holds also for areas which were considered to be shared or not subject to national jurisdiction. The duty of due diligence is necessarily a stringent one as ITLOS found with respect to the marine environment, a finding applicable to other areas relevant here. The assertion whereby the obligation to not cause significant transboundary harm applies solely within the framework of relations between neighbours has no basis, be it legal or logical. The key is to know whether the acts or omissions of one state produce such harm outside its own territory. Little matter that it be a few meters away or a few thousand kilometers away. Distance, distinguished members of the court, is not a circumstance precluding wrongfulness. The right to a clean, healthy and sustainable environment is also part of general international law. It is not, as some have claimed, something merely to aspire to. Whether it is expressed explicitly in a normative instrument or not, it derives from the simple finding whereby the effects of climate change on the environment affect and impinge upon access to water and food, to health, and even to life itself. Like the right of peoples to self-determination, it cannot be denied that the right to a healthy environment thus becomes a fundamental presupposition for the exercise of other human rights. Your court has already established that states are responsible for human rights breaches, even if those breaches are committed outside of their territory. This criterion applies to all acts or omissions of states which infringe human rights. Let us not conflate the scope of human rights treaties and the obligations of states in that respect, which flow from customary international law. Regarding the latter at least, it's not territorial jurisdiction which determines the obligation and its breach, it's the result. Distinguished members of the court, given what we've heard over the last few days, I think it's pretty regrettable that we need to recall that contemporary international law does not authorize states to breach human rights of persons who are beyond their jurisdictional control. The fundamental principles of international law, such as the right of peoples to self-determination and respect of territorial integrity, are called into question once you deprive states and peoples of their living conditions, of their resources, of their territory, of their maritime areas. Intergenerational equity is also fundamental to your analysis. Like the Inter-American Court, the European Court of Human Rights and other bodies, you have recognized the importance of taking into account future generations when you define the environment and its protection. Some participants have invited you to not examine the question of international responsibility for wrongful acts in advisory proceedings. Now, you've already done this many a time. Furthermore, nobody is asking you to find any individual state at fault. The invitation which some have made to you to eschew the question posed to you on the grounds of some alleged legal void is not persuasive. These proceedings right now are there precisely to shed light for states on how the law of responsibility applies to transboundary harm caused by GHG emissions. It is then up to them to examine their conduct and their situations, either as an injured state or a state at fault, to bring them into line with the law. The existing rules already allow this to be done. The principle of common but differentiated responsibility set out in the Rio Declaration has been invoked time and again and accepted by states. This principle also plays an important role in how you identify state responsibility within the context of climate change. Now, the question is not to know if a particular greenhouse gas emission by state A has directly caused loss and damage to state B. Now, we know today that anthropogenic emissions are responsible for global warming. The causal nexus is to be found there. The determination of individual responsibility is done subsequently on the basis of historic and current contributions, so that the proportion of harm caused to a climate system and to the environment becomes quantifiable. Now, far from being some progressive development, this result flows from the law of responsibility as it exists today, and which allows determination, when a number of states together commit an internationally wrongful act, to determine individual responsibility of each of them on the basis of their conduct. And this be it with regard to the environment or anything else. As the ILC asserted in its commentary on Article 47, I quote them, each state is separately responsible for the conduct attributed to it. This responsibility is not diminished or reduced by the fact that one or several other states are also responsible. End of citation. Scientific evidence shows that it is possible to determine the causal relationship between greenhouse gas emissions of certain states and climate change. To conclude, Mr. President, distinguished members of the Court, we invite you to consider the following elements to be included into your answers. In response to question A, international law imposes on states the following obligations. 1. The obligation to demonstrate due diligence in the way they deal with greenhouse gas emissions. 2. The obligation to prevent environmental harm caused by greenhouse gas emissions coming from the territory under the sovereignty or control of the state. 3. The obligation to not cause significant transboundary environmental harm on the territory of another state or in areas situated beyond national jurisdiction. 4. The obligation to protect ecosystems. 5. The obligation to take into account the consequence of greenhouse gas emissions for future generations. 6. The obligation to protect the marine environment. 7. The obligation to respect fundamental human rights, which include the right to a clean healthy and sustainable environment, the right to life, the right to health, and the right to food and water. 8. The obligation to respect equality of rights and the right of peoples to self-determination. 9. The obligation to respect the territorial integrity of states and peoples. 10. The obligation to repair the consequences of internationally wrongful acts. 11. The general obligation to cooperate. In carrying out these obligations, states also have to take into account, in due fashion, the ecosystemic approach, the principle of intergenerational equity, and the principle of common but differentiated responsibilities and respective capabilities of states. Now, in response to question B, 1. States found responsible for breaches of these international obligations are obliged to cease this act and to offer appropriate assurances and guarantees of non-repetition if the circumstances require. And they have the duty to continue to perform the breached obligations. 2. To cease the conduct in question also includes taking mitigation measures to achieve the drastic reduction of greenhouse gas emissions. 3. States held responsible by their acts or omissions of the commission of internationally wrongful acts on account of their past or current greenhouse gas emissions have the obligation to repair the loss and damage caused to other states, peoples, and individuals. And that includes, depending on the circumstances, restitution, compensation, and satisfaction. 4. The effect of sea level rise due to anthropogenic climate warming impacting coasts and island features does not entail the loss of maritime areas. 5. All states and other international actors must recognize that existing maritime areas are maintained as they were measured and communicated pursuant to international law or as decided by a court or international tribunal. 6. States have the duty to cooperate in order to obtain the cessation of the aforementioned international breaches of international obligations and integral reparation of the loss and damage caused. 7. States have the duty to cooperate with respect to common but differentiated responsibilities and according to their respective capabilities in the protection of the environment. Mr. President, distinguished members of the Court, we don't ask you to transform yourself into superheroes using the law to save the world. We are not suggesting to you at all to hand down an opinion de lega ferenda or to rule ex equo e bono. What we are proposing is neither more nor less to exercise your advisory jurisdiction to its full extent. If you fulfill your function, you will have taken a real step forward, a small step perhaps, if you look at all that remains to be done, but a big step in enabling general international law to play the role it should play. Like the tolling of a bell, your reply may wake up the world's major decision makers so that they may, on the basis of the law, and once and for all, take the measures required to tackle this urgent and current ecological crisis. Mr. President, distinguished members of the Court, thank you for your kind attention, and that brings to an end the oral presentation of Costa Rica.
Je remercie les représentants du Costa Rica.
I'd like to thank Costa Rica and I now invite the delegation of Côte d'Ivoire to take the floor.
Monsieur le Président,
Mr. President, members of the Court, it is an honor for me to appear before you today on behalf of the Republic of Côte d'Ivoire. Let me present to you the arguments of my country on the pending issue of climate change. Mr. President, as is the case for other other states in the world, climate change and fighting against it is indeed a major and pressing cause for Côte d'Ivoire. Indeed, over the last few decades, we have seen an increase of adverse consequences of climate change, which have worryingly disturbed the environmental balance and the socio-economic life of our country. Looking at the various industries, farming, forestry, water resources, coastal areas, energy, infrastructure, transport, health, all of this highlights significant climate-related risks. According to the World Bank's Country Climate Development Report in 2023, the impact of climate change may push 1.63 million people into poverty by 2030 and bring our GDP down 13% by 2050. According to the NDGAIN Country Index on Vulnerability, Côte d'Ivoire is one of the most vulnerable countries. It is also the 47th least well-prepared country. In this context, fraught with gaps, we have adopted policies, strategies, programs, projects and plans, and a stronger institutional and legislative framework to address this. All of this, of course, done under our international obligations. Côte d'Ivoire is a party to many international agreements, the main ones being the UNFCCC, the Convention Against Desertification and Drought, the Convention on Biodiversity, and the Paris Agreement on Climate. In this year, we also signed the BBNJ agreement on marine biodiversity on the areas beyond national jurisdiction. Similarly, we are engaged in our region, which is why Côte d'Ivoire has adopted a new set of innovative and protective legal measures. We also contribute to the coordination of climate implementation by establishing a coastal areas inspectorate, an environmental enforcement administration, and others. International obligations must be performed under the principle of CBDRC. Developed countries' obligations are key as concerns technology transfer, capacity building, especially as concerns the climate change financing. It is necessary to increase green investment credits to finance such goals for conservation and sustainability. We have, as I said, a whole range of social sustainable development projects relating to solar energy, e-mobility, waste management, land use, etc. Mr. President, given the increase in temperatures and the increasing occurrence of extreme weather and climate events, and slow developing phenomena, Côte d'Ivoire advocates an urgent strengthening of states' actions so as to improve the capacities of developing countries to adapt and mitigate. The real issue is and remains financing. This would enable us to go on strengthening our actions to fight and eradicate poverty across the board. Côte d'Ivoire advocates climate justice that would protect the current environment, but also the environment for future generations. Let me, at this juncture, sir, thank you on behalf of my government's authorities. If you'd allow me, sir, I should like to give the floor to Professor Armand Savarian, who will give you our country's oral presentation. The President, let me now give the floor to Mr. Armand Savarian. You have the floor, sir. President, Côte d'Ivoire echoes what a number of participants have said.
They should, to the extent possible, be interpreted so as giving rise to a single set of compatible obligations. Vu la jurisprudence des cours nationales, du titre et des cours...
Given the domestic jurisprudence, ITLOS, and other human rights courts decisions, we know with Portugal and others that the court's jurisdiction is an opportunity to systematically clarify and systemically clarify the legislation applicable. As Spain and Namibia and Colombia and others have said, we agree with the harmonious interpretation clause of Article 31(3)(c) of the VCLT. As concerns the two forms of lex specialis which have been mentioned under the second written submissions, we consider that it is not an exclusion of one by the other, rather an application of each form of lex specialis to respective issues. First of all, it harmonizes the relationship between the Framework Convention and the Paris Agreement. The Framework Convention was signed in 1992 in specific circumstances of the time, of the day, while the Paris Agreement is an implementing treaty signed in 2015. We agree with South Africa, Brazil, Nordic countries, Kuwait and France as concerns the harmonious integration as a whole. For instance, the integration of mechanisms to provide financial and technical assistance. We support the comments of the United States and others according to which lex posterior provides that the Framework Convention applies only to the extent that its provisions are compatible with those of the Paris Agreement. Secondly, this brings climate law into international customary law, as was the case in the pulp mills case. We hold that the lex specialis applies in the first way, as in a simultaneous application of the special rule to the general rule, not exclusion of the international customary law, which is forever changing. So both regimes are indeed aligned.
The applicable customary rule would not give rise to parallel regimes operating simultaneously with different content. Troisièmement, cette règle gère le rapport.
Thirdly, this rule governs the relationship between these treaties and other specialized fields, such as law of the seas, human rights, and investment law. Let us recall the fact that the Paris Agreement rules apply to other regimes as far as they concern climate law. The other regimes remain distinct for those issues that are not covered by the Paris Agreement. New Zealand mentions Article 192 of ITLOS that provides for the taking of measures as far-reaching and efficacious as possible to prevent the deterioration and the deleterious effects of the climate change. We also agree with the EU
to have the effect of imposing general substantive requirements regarding the limiting of GHG emissions on state parties, but rather as setting an exacting and stringent standard. Nonobstant les obligations distinctes sous-mentionnées de la...
Notwithstanding these obligations, we hold that states parties may abide by their obligations under UNCLOS by implementing their obligations under the Paris Agreement as supplemented by customary transboundary rules. The dynamic state of customary law binds both treaty-based regimes and also avoids any conflict to law. Côte d'Ivoire considers that customary law does not apply to the interpretation of the Paris Agreement. We should therefore consider that customary obligations to evaluate and have environmental impact assessments must come under Article 4 to comply with Article 194. As Pakistan, we consider that the touchstone in the Paris Agreement is the collective obligation, and we therefore support what Australia and others have said, that it is not a binding provision given its drafting history. Given the consensus on individual obligations under Article 4, we submit that the collective objective is the internal context for its interpretation and permeates construction. We therefore consider that individual construction obligations are vital. In this respect, neither text nor subsequent decision have clarified the words significantly below 2 degrees.
Temperature goal is a range instead of one fixed level. It is submitted that a ceiling exists between the horticulture ambition to pursue efforts to limit the temperature increase to 1.5 degrees and the reference point of 2 degrees. Bien que certains participants soutiennent que la limite est au-dessus.
Though some participants have said that the limit is below 1.5 degrees, but this is not justified in the light of the words actions undertaken. The internal context must follow the precautionary principle. We hold that the interpretation, the most interpretation is therefore 1.6, and as it is the less dangerous one over 1.5.
International aviation and shipping emissions is delegated to the ICAO and IMO. While Article 2.2 of the Kyoto Protocol is spent, New Zealand has noted that the Paris Agreement and CMA decisions thereto do not provide for their exclusion from mitigation duties. Segregated reporting by state parties in greenhouse gas inventories reflects the special methodologies for the attribution of transnational emissions. The CORSIA and MARPOL are voluntary schemes, while civil aviation alone accounted for 2.76 degrees of global emissions in 2019. Not addressed by the ITLOS, it is submitted that their exclusion from mitigation duties without a collective decision is inconsistent with Article 4.1. As the United States and others have noted, Article 4, as the core mitigation provision, applies to all state parties. Though ambiguous on its own terms, the drafting history of paragraph 1 shows it to be internal context, linking the binding duties in paragraphs 2 and 3 to the collective objective in Article 2.1. Building upon a consensus that paragraphs 2 and 3 are obligations of conduct rather than result, Côte d'Ivoire supports the argument of the EU, Seychelles and others that they are obligations of conduct leading to a precise result. As the Court stated in the Nuclear Weapons Advisory Opinion, quote, the legal import of that obligation goes beyond that of a mere obligation of conduct. The obligation involved here is an obligation to achieve a precise result, nuclear disarmament in all its aspects, by adopting a particular course of conduct, namely the pursuit of negotiations in good faith, end quote. Just as the destructive power of nuclear weapons cannot be contained in either space or time, so does severe global warming carry, quote, the potential to destroy all civilization and the entire ecosystem of the planet, end quote. It is this global scope that distinguishes them even from the duty in the Genocide Convention to prevent and punish the crime of crimes. Nous observons que la grande majorité des participants sont d'accord sur l'application aux alinéas 2 et 3.
We note that the participants agree on subparagraphs 2 and 3 of the customary rule relating to due diligence. These have been applied by the court to local environmental circumstances up until now, but we hold that they also apply to global.
Paragraph 3 does not set a numerical duty of mitigation. While state parties enjoy a margin of appreciation to design and implement their NDCs, they must nevertheless comply with the prescribed criteria. In particular, the stipulation of progression entails a continuous rise in ambition. Whilst Kuwait and the United States have argued that the word will instead of shall carries a hortatory meaning, Côte d'Ivoire concurs with the EU and others that the word, quote, carries more weight than a term such as should, but does not elevate the obligation to one of result, for instance, by using the word shall, end quote. Whereas Kuwait, Saudi Arabia and the United States maintain that the standard of NDCs is exclusively determined by each state party, Côte d'Ivoire agrees with Australia and others that they must be aligned to the object and purpose of the collective objective, as decided by the CMA in 2022. This alignment is evaluated against the global stocktake in the annual synthesis reports under the Enhanced Transparency Framework. Whilst Iran, India, China and others have argued that performance by developing states of their mitigation duties is conditional upon the performance by developed states of their duties of cooperation and assistance, we concur with Colombia, the EU and others that no such derogation is permitted. Whilst Timor-Leste and Colombia note the reality that states dependent upon the provision of assistance cannot meet their own obligations to the fullest, conditionality of performance under Article 4.7 of the UNFCCC has been replaced under the Lex Posterior rule by the universality of Article 4 of the Paris Agreement, alongside the duties of assistance under Articles 9 and 10. This accords with the conclusion reached by the ITLOS in May. Whilst paragraph 4 uses the hortatory word should, it forms part of the internal context to paragraphs 2 and 3 to construe the higher standards of mitigation for developed states. In the Urgenda case, the Supreme Court held the Netherlands to be bound to fulfill its individual duty to implement the collective objective. This interpretation is also reflected in the Grand Saint, Orsainfranc and Neubayer judgments, as well as the pending case of Klimatzak. In Klimasenioringen, the court found Switzerland to have breached the convention by failing to set a carbon budget from 2020. Like the German Constitutional Court, the court declared NDCs lacking an effective regulatory framework, including a carbon budget, insufficient. Côte d'Ivoire thus submits it to be a requirement under paragraph 3 to produce a carbon budget and align it to the annual synthesis reports. As the 2023 report shows that 94% of state parties produce carbon budgets and 80% economy-wide targets, we agree with the United States that, quote, there is now a clear expectation that all parties' next NDCs should have economy-wide emission reduction targets covering all GHGs, and that such NDCs should be 1.5 degree aligned, close quote. This practice accords with the Urgenda and other judgments, in which the courts held the authorities to have fixed inadequate national targets over the respective periods. La Côte d'Ivoire soutient le commentaire de la Suisse et d'autres.
Côte d'Ivoire agrees with Switzerland and others, according to which there is consensus to mean that subparagraph 3 does not demand achievement of the targets, whatever the circumstances. Having the reference to the highest possible level means that we have to do our utmost to reach the expected goals. States do have some measure of appreciation, but they have to implement their NDCs and carbon budgets. In the Urgenda case, the authorities hadn't justified their downsizing to 20% when it should have been a maximum at 25%. According to the EU, France and the Netherlands, the obligation to take additional regulatory and administrative measures under subparagraph 2 applies. In Grande-Sainte and Oxfam, France, French courts ordered additional measures to reach the national goals, having found the 2019 and 2019 emission reductions insufficient.
The Court of Justice held in Friends of the Earth that the carbon budget of the United Kingdom was based upon the flawed assumption that each measure would be fully implemented. Côte d'Ivoire supports the arguments of the Bahamas and others that the due diligence standard of the Pulp Mills case requires the vigilant enforcement of rules and administrative control of public and private operators. As Sierra Leone and others have argued, a key duty is to evaluate the environmental impacts of planned activity under its jurisdiction or control at the project and sector levels, holding it to be, quote, imperative for states like India to uphold their obligations under international law to mitigate greenhouse gas emissions, close quote. The Supreme Court of India decided in March to balance its NDCs on transitioning from fossil fuels to renewable energy with the need to protect biodiversity. In 2020, the Supreme Court of Mexico relied upon its NDCs under Article 4.3 in annulling an executive decision increasing the maximum percentage of ethanol in petroleum due to a failure to evaluate its emissions impact. As Singapore, Cameroon and others have averred, customary international law obliges states to apply the precautionary principle. While Switzerland rightly notes that Article 4 is based upon territoriality, Côte d'Ivoire concurs with Mauritius, Belize and Namibia that the due diligence standard applies not only to direct emissions from controlled sources and acquired energy, but also indirect emissions from downstream consumption, Scope 3 emissions. In June, the UK Supreme Court held in the Finch case that the EIA of a local government for the extraction of crude oil had failed to account for the Scope 3 emissions that would inevitably result from its consumption. In the Grey and Gloucester cases, the Australian courts reached the same conclusion for coal mining projects. As Albania and others have argued, this mitigation duty can provide a host state with a defence or counterclaim in international investment law, such as the denial of a fossil fuel mining permit, taxes imposed on the hydrocarbon sector, or a ban on fossil fuels. À propos de l'expression, c'est
as concerns the expression CBRDRC, Côte d'Ivoire echoes what France and others have said, according to which the terms developed countries and developing countries is not a static structure, but in fact relies on a dynamic, adaptable system adjusted to the circumstances of every state. This has been clarified by ITLOS.
Have argued. Differentiation according to national circumstances is reflected in wealth, technical capacity and human development. Some states with high socioeconomic indicators, such as Saudi Arabia and Kuwait, have argued that they should benefit from a slower pace of decarbonisation under Article 410 of the UNFCCC due to their reliance upon fossil fuel production for national income. However, it is submitted that they are obliged under Article 4.3 as lex posterior to transition away from fossil fuels deeper and faster than exporters with low indicators, such as Timor-Leste and Colombia.
As concerns the geographical scope, we echo Australia in saying that they have a territorial base but can be transborder in specific circumstances, and that is in line with Article 2, subparagraph 1 of the International Covenant on Civil and Political Rights, and also the advisory opinions in the Namibia and Wall case. We therefore support the narrow approach of this ECHR in Agostinho rather than the broader one of the IACHR and the Human Rights Committees. Even though some have said that there is no obligation to mitigate under human rights treaties, others recognize that it has been recognized by the ECHR, the Inter-American Court, and others.
There has been insufficient information in Billy and Australia to uphold the alleged failure to take adequate mitigation measures. It nonetheless ruled the complaint admissible. Côte d'Ivoire supports the majority of participants that mitigation can be incidentally engaged by a human right. Turning to question B, whereas some participants have argued that Article 8 of the Paris Agreement implicitly excludes the general law of state responsibility, Côte d'Ivoire concurs with Samoa, Canada and Ecuador that this construction contradicts the existence of a compromissory clause in Article 24. Whilst Article 8 does not itself provide a basis for liability or compensation, we support Japan, Latvia and others in submitting that it is not a waiver and that the lex specialis rule in Article 55 of the 2001 articles does not apply in the absence of general rules of responsibility in the Paris Agreement. La RDC explique que
the DRC explains that the law on international responsibility may apply to climate change in specific contexts, especially on interstate claims and individual claims against a state nationally, as the international human rights courts have indeed found. Claims under the aforementioned compromissory clause are restricted to the first form, even though both are agreed to and accepted under the covenants.
Leste and others that Article 13 excludes historical responsibility for emissions produced before the entry into force of the mitigation duties prescribed by the climate change treaties. As Australia has submitted, even if a composite act or continuing act within the meaning of Articles 14 and 15 could be shown, whether, quote, the state has breached the obligation could only be assessed by reference to the conduct of the state that occurred after that obligation came into existence, end quote. Côte d'Ivoire concurs with the Solomons and others that the question of breach principally entails evaluation of performance under due diligence. As the Bahamas, Australia and Solomons have noted, duties of adaptation can arise for displaced persons. In the Teitota case, the Human Rights Committee accepted the argument of a climate refugee applicant that Kiribati would likely become uninhabitable within 10 to 15 years due to sea level rise, and non-refoulement obligations can be engaged under the covenant. Regarding the impact of sea level rise on the maritime rights of particularly vulnerable states, Côte d'Ivoire supports the arguments of Tonga, Latvia, the Solomons and others that the submerged territory and displaced population of such states would satisfy the customary criteria for statehood by the presumption of continuity. Through reinterpretation of the UNCLOS in state practice, maritime entitlements, including those connected to ambulatory baselines, should be retained by states, while submerged islands should continue to satisfy the Article 121 definition.
As concerns indirect causality as identified by China and others, Côte d'Ivoire has found no state practice supporting strict liability. We consider that the courts are able to assess the situation in the light of expert testimonies and documentary evidence and establish factual responsibility. That is to say the effect of global change and global warming on damages claims and greenhouse gas emission claims. In the Nicaragua, certain activities carried out by Nicaragua, the court found that you had to rule on the existence of a sufficient causal link between the wrongful act and the injury suffered. We support what France has said concerning the ILC, under which the attribution of conduct to a state relies on specific criteria and not by a factual causality. In the specific context of global warming, we consider that the legal causality relies on a proximity test, and we hold that scale and seriousness are the criteria. The tribunals have not assessed damages and in Ogenda, Constant and others. We consider that this would be nonetheless applicable and acceptable under the current case law. As France states, the ECHR does not set aside causality.
47.1, as cited in Klimazenarinen and others, enables the apportionment of responsibility on an individual basis. though agreeing with Portugal that erga omnes standing under Article 48(1)b does not yet reflect customary international law, we concur with the Netherlands and others that state practice and opiniones juris have sufficiently gestated for the crystallization of erga omnes partes under 48(1)a. As a treaty of general concern, states other than the injured state may thus invoke responsibility under the Paris Agreement. Mr. President, members of the Court, we thank you for your attention. Those are our submissions.
I thank the representative of Côte d'Ivoire for their presentation. I will now invite the representatives of Denmark, Finland, Iceland, Norway, and Sweden to make their joint presentation to the Court. I shall call upon Ms. Kaija Suvanto, speaking on behalf of this group of states, to address the Court. Madam, you have the floor.
Mr. President, distinguished members of the Court, I have the honour to appear before you today in the present proceedings on behalf of the Nordic countries, Denmark, Finland, Iceland, Norway and Sweden. I am here today as the legal advisor of my own country, Finland, and joined by the legal advisors of all the other Nordic countries. We wish to use this opportunity to convey our shared views on the key issues engaged by the questions put to the Court. The Nordic countries recognise that climate change poses an existential threat and constitutes a defining challenge of our time. The science is clear. It speaks of rising sea levels with the possibility of severe consequences for low-lying coastal areas. It speaks of extreme weather, drought and changes to ocean currents. We see climate change affecting patterns of migration and displacement. We fear increased potential for conflict over scarce resources and other dramatic impacts on life on Earth. The Nordic countries welcome the Court's consideration of the obligations of states in respect of climate change. The unique role and composition of the Court as the principal judicial organ of the UN sets the Court apart from other judicial bodies and tribunals, domestic or international, that may be engaged with similar questions in a context of a significant number of proceedings and overlapping litigation initiatives. We trust that the Court's examination of applicable law will offer a much-valued contribution in terms of clarifying existing obligations. Its decision may hopefully also highlight and inform the interrelationship between the relevant rules of international law that may be applicable to the issue at hand. Mr. President, in the remainder of the time allotted to us, I shall first address the role of the UN climate change regime as part of the international response to the threat of climate change. Mr. Christian Jervel, the legal advisor of Norway, will thereafter address the core obligations enshrined in that regime and the interrelationship between the UN climate change regime and other relevant rules of international law relating to the obligation to prevent damage to the climate system and the environment caused by the anthropogenic emissions of greenhouse gases. Ms. Vibeke Palstenak Jørgensen, the legal advisor of Denmark, will then finally address the question of customary international law and possible legal consequences under relevant international obligations to the extent relevant to these advisory proceedings. Mr. President, the questions posed to the Court and the interventions made during these proceedings refer to the rules and instruments from several fields of international law. In this context, the Nordic countries underline that the UN climate change regime is the principal body of international regulations, setting out obligations of states to ensure the protection of the climate system for anthropogenic emissions of greenhouse gases. It is also the primary vehicle for driving forward the global response to climate change. The UN climate change regime has been carefully developed through political negotiations over the course of the last 30 years. It comprises the 1992 United Nations Framework Convention on Climate Change, the 1997 Kyoto Protocol to the Framework Convention, and the 2015 Paris Agreement. It also comprises several supporting institutions and arrangements, such as the Conference of the Parties to the Framework Convention, the COP, and the Conference of the Parties serving as the meeting of the parties to the Paris Agreement, the CMA. The large number of decisions taken within these frameworks to facilitate the implementation of the agreement is also part of the regime. The negotiation and political work within this framework constitute the main forum for increasing global action to respond to the threat of climate change. It has delivered carefully formulated decisions over the years. Combating climate change is a global challenge and it depends on global solutions. This is what the UN climate change regime is established to facilitate, including through the provision for the negotiation of any further obligations within the COP and the CMA. Mr. President, honourable members of the Court, I thank you for your attention. I will now ask Mr. Christian Jervel, the legal advisor of Norway, to come to the podium to elaborate on the core obligations of the UN climate change regime.
I thank Ms. Wantu, and I'll give the floor to Ms. Christian Jervel. You have the floor, sir.
Mr. President, distinguished members of the Court, it's a privilege to appear before you today as the legal advisor of Norway and present these observations on behalf of the Nordic countries. Turning now to the structure and operation of the UN climate change regime. The views of the Nordic countries concerning the details and operation of this system are set out in our written statement offered to the Court in these advisory proceedings. I shall briefly recapitulate some main observations with an emphasis on the Paris Agreement, which constitutes the most recent international consensus on critical issues within the UN climate change regime. The objective of the Paris Agreement, as well as of the UN climate change regime itself, is to strengthen the global response to the threat of climate change through a combination of legal obligations and political targets, including within areas such as mitigation, adaptation and finance. The Paris Agreement is built on a system of collective responsibilities for all parties, which ensures progression over time and furthers the global response to the threat of climate change. As set out in Article 2, Paragraph 1, Litra A of the Paris Agreement, the long-term temperature target is to hold the increase of the global average temperature to well below 2 degrees Celsius above pre-industrial levels, and to pursue efforts to limit the temperature increase to 1.5 degrees Celsius. The core obligations of the Paris Agreement are procedural in nature. At the center of these obligations is the 5-year ambition mechanism established in Article 4 of the Agreement. This mechanism lays out an obligation for all parties to prepare, communicate and maintain a nationally determined contribution, an NDC. The procedural obligation to prepare, communicate and maintain an NDC every 5 years is an obligation of result. The achievement of the NDCs is an obligation of conduct. Parties shall pursue domestic mitigation measures with the aim of achieving the objectives of the NDCs. To this end, each party's successive NDCs will represent progression and reflect the highest possible ambition, reflecting common but differentiated responsibilities and respective capabilities in the light of different national circumstances. When communicating an NDC, the parties shall be informed by the outcomes of the global stocktake. Together with the long-term temperature goal of the Paris Agreement, the element of progression and highest possible ambition, as well as the link to the global stocktake, all this together lay out a standard of due diligence for each party in formulating its NDC. Mr. President, science is clear. We are not on track to meet the goals of the Paris Agreement. Our efforts are currently insufficient, and our actions towards climate change have been criticized for being insufficient and not up to the challenge it represents for present and future generations. The Nordic countries share the sense of urgency and the impatience with regards to seeing solutions take effect, and we recognize that we must step up our actions. However, it is the view of the Nordic countries that the Paris Agreement and the structure that it offers provides the best possible avenue to facilitate the global solutions that we need, and that it is up to us, as parties to the agreement, to step up our efforts. In this regard, the Nordic countries would like to note that the Paris Agreement is designed and structured to work over time and ensure the parties increase their efforts in 5-year cycles. The first global stocktake took place at COP28 in 2023, where the states parties took stock of the implementation of the agreement and assessed the collective progress towards achieving the purpose of the agreement. It was agreed to an ambitious roadmap for getting the world on track to the Paris Agreement's long-term goals. In 2025, state parties shall submit their second NDCs, and for the first time, the parties must develop NDCs that are to be informed by the result of the global stocktake. The new NDCs must also represent progression from the previous NDCs and represent the parties' highest possible ambition. Mr. President, different views have been expressed in the course of these proceedings concerning the differentiation of obligations in the Paris Agreement. In this regard, the Nordic countries would like to reiterate that the Paris Agreement establishes obligations for all parties. The structure of the Framework Convention and the Kyoto Protocol have been intentionally developed or replaced in favor of new solutions in the Paris Agreement. This was a conscious choice taken in the interest of furthering the core objective of the Paris Agreement, namely, to strengthen the global response to the threat of climate change, and to do so by improving upon and enhancing the implementation of the Framework Convention. Mr. President, in the case of norm conflict between the various instruments in the UN climate change regime, the Paris Agreement should prevail. I refer here to the fact that the Paris Agreement is both the latest treaty and the treaty with the most precisely delimited scope of application. The well-established techniques for the resolution of norm conflicts, including the principles of lex posterior and lex specialis, imply that the most recent consensus amongst the state parties to the UN climate change regime shall take precedence. One of the central departures from the former instruments was the agreed change from the annex-based system in the Framework Convention, under which only a limited number of the parties had specific commitments. Contrary to that system, the Paris Agreement establishes obligations and targets for all parties, reflecting their capabilities and their different national circumstances. This is reflected in Article 2, Paragraph 2, which stipulates that the agreement will be implemented, and I quote, to reflect equity and the principle of common but differentiated responsibilities and respective capabilities in the light of different national circumstances." Unquote. This means that the level of ambition will depend on the individual capacity of each state to meet its obligations. This is not a static concept. The capacity of any state with regard to contributing towards our common responsibility may evolve over time as national circumstances change. The principle of common but differentiated responsibilities and respective capabilities as applied in the Paris Agreement serves to inform the understanding of what can be expected from each state. Against this backdrop, it is the view of the Nordic countries that the Paris Agreement represents a more dynamic approach to the question of differentiation of responsibilities between the parties compared to the arrangements included in previous instruments. While parties may implement and fulfill the obligations differently, the model of progressive ambition ensures that all state parties are regularly increasing contributions to be on track to fulfill our common overarching responsibility. This notably serves to abandon the bifurcated and static approach of linking obligations to annexes, as set out in the Framework Convention. It also creates a structure to facilitate that all state parties make effective contributions towards addressing our common concerns. Nature is not interested in the origin of a contribution, but its net effect for the mitigation of climate change and environmental harm. That is why it is important that the Paris Agreement creates a system that establishes obligations for all. We cannot solve the climate crisis, without the best efforts of all. Mr. President, I will now turn to the systemic relevance of the United Nations climate change regime for the interpretation of rules external to that regime. The questions posed to the Court are broad in their scope and invite examination of rules and principles under several fields of international law. In addition to the already mentioned rules under the UN climate change regime, the resolution refers, inter alia, to the law of the sea, human rights, and customary international law. In this context, the interrelationship between the various legal regimes and instruments applicable to the issues of anthropogenic emissions of greenhouse gases is brought to the fore. The Nordic countries believe that the Court's role as the principal judicial organ of the United Nations and the international system more broadly places it in a unique position to inform these issues and clarify the interrelationship between relevant rules. While the formation of international law is not in all regards a coordinated process based on plans for construction of logically coherent systems of norms, meaningful relationships do exist and may be identified between rules and legal regimes in the international legal system. The key principle for the organization of the interrelationship of rules in the international legal system is the presumption of compatibility between obligations applicable between the same parties. This has been referred to by the International Law Commission as the generally accepted principle that when several norms bear on a single issue, they should, to the extent possible, be interpreted so as to give rise to a single set of compatible obligations. Within the law of treaties specifically, a principle of systemic integration is reflected in Article 31, paragraph 3, litera C, in the Vienna Convention on the Law of Treaties, which provides that any relevant rules of international law applicable in the relations between the parties shall be taken into account in the interpretation of treaties together with the context. Mr. President, the Nordic countries believe that the UN climate change regime is central to the global response to climate change and that it must be accorded systemic relevance when examining the possible obligations of state under other instruments and fields of law to ensure the protection of the climate system and other parts of the environment from anthropogenic emission of greenhouse gases. The UN climate change regime, and the Paris Agreement in particular, is a key interpretative factor in any process seeking to determine the possible existence and scope of obligations relative to that same issue under other instruments. Where such instruments establish obligations of conduct, and where such instruments are to be applied to evaluate whether a state has acted with the appropriate due diligence with regard to reducing anthropogenic emissions of greenhouse gases, the determination of what constitutes due diligence in that context would be informed by the expectations for such reductions as set out in the Paris Agreement, which reflects the most recent consensus among states on the matter. In relation to the marine environment, for example, the Court should look at the United Nations Convention on the Law of the Sea, which sets out the legal framework within which all activities in the oceans and seas must be carried out. However, in the application of a standard of due diligence under the Convention relating to marine pollution from anthropogenic emission of greenhouse gases, the Convention cannot be considered in a vacuum. This entails that the Convention must be understood with due regard to other relevant and compatible rules of international law applicable in the relation between the parties. The Nordic countries note that this view is also substantiated by the observation of the International Tribunal of the Law of the Sea in its advisory opinion of 21st May 2024. I quote from paragraph 222. The UNFCCC and the Paris Agreement, as the primary legal instruments addressing the global problem of climate change, are relevant in interpreting and applying the Convention with respect to marine pollution from anthropogenic GHG emissions. In particular, the temperature goal and the timeline for emission pathways set out in the Paris Agreement inform the content of necessary measures to be taken under Article 194, paragraph 1 of the Convention. End of quote. Mr. President, honourable members of the Court, I thank you for your kind attention. I will now ask Ms. Vibeke Pasternak-Jørgensen, the legal advisor of Denmark, to come to the podium to address the question of customary international law.
I thank Mr. Gerbel. I now give the floor to Ms. Vibeke Pasternak-Jørgensen. You have the floor, madam.
Mr. President, distinguished members of the Court, it is an honour for me also to appear before you today and deliver the final part of the statement on behalf of the Nordic countries. The questions put to the Court invite an examination of possible obligations under customary international law that may have a bearing on environmental damage stemming from anthropogenic emissions of greenhouse gases. The Court has, in the Corfu Channel case, among other cases dealing with transboundary environmental consequences, stated that states have an obligation under customary international law to exercise due diligence in not knowingly allowing their territory to be used for acts that prejudice the rights of other states. This would include acts that cause significant damage to the environment of another state. Also, in the pulp mills case, the court further referred to the principle of prevention as a customary rule with origins in due diligence that is required of a state in its territory, stating that, and I quote, "A state is thus obliged to use all means at its disposal in order to avoid activities which take place in its territory or in any area under its jurisdiction causing significant damage to the environment of another state." Unquote. Mr. President, we note that the argument has been made in the course of these proceedings that the obligation to prevent transboundary environmental harm also applies with regard to anthropogenic emissions of greenhouse gases. The Nordic countries wish to point out that the standard applied in the cases that I just referred to has been developed based on state practice relating to direct and manifest injury in bilateral affairs. It has not in any situation thus far been applied outside that context to cases of alleged harm to natural systems or other more abstract elements that might in turn lead to consequences somewhere else on the planet. The obligation of states under customary international law to prevent significant transboundary harm to other states or to areas beyond national jurisdiction is generally worded and neutral as to the source of harm. Furthermore, there is no evidence in state practice or in opinio juris among states that this obligation can be transposed to specific obligations under international law to ensure the protection of the climate system or the prevention of consequences due to climate change. It is, in our opinion, important to note that the harm in question must qualify as significant damage and affect the environment of another state or area beyond national control. A significant harm, evidentially resulting from the anthropogenic emissions of one state within its own jurisdiction, could, in principle, qualify as a relevant source of significant harm to an area beyond that state's jurisdiction. However, the ascertainment of a link between the emissions of one particular state and a specific harm beyond that state's jurisdiction attains particular complexity, considering that there is no generally accepted standard for the determination of the effects of a specific act on the climate system and other parts of the environment. Nor is there any specific standard that is accepted by states for the apportionment and causal interrelationship of the combined emissions of states. The Nordic countries stress that a determination as to whether a state, through anthropogenic emissions of greenhouse gases, has reneged on a general obligation to act with due diligence to prevent significant transboundary harm would need to take into account the extent to which that state has taken the steps expected of it under relevant instruments of international law, including, of course, in particular, the Paris Agreement. In line with the points mentioned, the Nordic countries question whether the obligation under customary international law to prevent significant transboundary environmental harm can be applied as such to climate change resulting from the shared activities of humankind. Mr. President, with the Court's permission, I will now present the observations of the Nordic countries concerning question B. I shall first note that the Nordic countries read the question of legal consequences as referring to an application of the rules of state responsibility to any situation of violation of primary rules identified under question A. In this context, the Nordic countries note the arguments put forward in the course of these proceedings that raise questions relating to historical responsibility and the view according to which certain states should bear a responsibility towards others. It is important to note that in connection with the adoption of the resolution that requested this advisory opinion from the Court, numerous states stressed the need for the Court to approach the issue of legal consequences and responsibilities with a view to clarifying existing international law and by that offer a contribution to future compliance. The questions posed to the Court are thus not based on any assumptions, presumptions or allegations towards certain states. The approach is forward-looking and not aimed at an assessment of any specific historical act or omissions or any specific case. Bearing this in mind, the Nordic countries also wish to highlight that the Paris Agreement is a result of careful considerations regarding the roles of all states, both developed and developing. The Paris Agreement does not refer to historical responsibility. During the negotiations of the Paris Agreement, questions of fair burden sharing were raised and different models were proposed to include such concepts. In the end, these ideas were all rejected. The Paris Agreement, however, does reflect differentiation in various provisions, such as under Article 4, Para 4, where developed countries, parties, should continue to take the lead by undertaking economy-wide absolute emission reduction targets. Another such example is found in Article 9, Para 1, according to which developed country parties shall provide financial resources to assist developing country parties with respect to both mitigation and adaptation. At the recent COP29, parties agreed to set a new collective quantified goal on climate finance of at least $300 billion annually by 2035, with developed countries continuing to take the lead and developing countries being encouraged to contribute. The decision also includes a call to all actors to work together to scale up finance to developing countries from all public and private sources to the amount of at least $1.3 trillion per year by 2035. The climate finance is not a matter of reparation, but a means to facilitating contributions towards achievement of our common goals of the Paris Agreement with a view to strengthening the global response to the threat of climate change. Let me now turn to the wording of question A and our remarks on state responsibility. The question refers to acts or omissions that have caused significant harm to the climate system and other parts of the environment. In the view of the Nordic countries, this does not constitute a legal standard, but a standard that must be established through interpretation of applicable and specific primary obligations. Turning to the assessment of any legal consequences for states under international law, we present our observations based on the draft articles of the responsibility of states for internationally wrongful acts that were adopted by the ILC in 2001. We consider that the draft articles in general reflect customary international law as already recognized by this Court. To determine that a state is responsible for an internationally wrongful act, the conduct in question must be attributable to the state under international law, and the conduct must constitute a breach of an international legal obligation that is in force for the state at that time. To consider contribution to climate change a potential internationally wrongful act is also conditioned upon the establishment of causality between one state's anthropogenic emissions of greenhouse gases and its interference with the climate system, thus giving rise to a breach of an international obligation of that state. The attribution of detrimental environmental impacts flowing from anthropogenic emissions of greenhouse gases engage complex questions of causation. These are intricately connected to the nature and function of global consumption patterns of energy systems and the combined requirements of life worldwide. There is no generally accepted set of criteria for the determination of a qualified link between the acts of one state and a specific detrimental consequence. In addition, the transboundary nature and global consequences of climate change give reason to draw attention specifically to Article 46 and 47 of the draft articles that deal with plurality of injured states and plurality of responsible states, respectively. We have noted the view put forward during the proceedings, according to which it's possible to identify a specific set or group of states to constitute a plurality of responsible states within the meaning of Article 47. However, the Nordic countries wish to highlight that this question cannot be prescribed in abstract, but must rely on an assessment of the primary obligation in question of each state concerned. In relation to climate change and state responsibility, the rationale behind the draft Articles 46 and 47 raises complex questions relating to distinguishing between the injured state and the responsible state. States assume both roles at the same time. The threat of climate change is a serious global challenge that requires a common and immediate response by all states and the international community. It is not a matter that can be reduced to an identifiable act or omission by any one state. In the view of the Nordic countries, the UN climate change regime, and in particular the Paris Agreement, is key to assessing to which extent any state has acted with the necessary due diligence to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases. Mr. President, honourable members of the Court, in conclusion, I will reiterate the main points of the Nordic countries. The global community is not on track to reach the long-term climate goals of the Paris Agreement. Further action is needed to combat the adverse effects of climate change. The Nordic countries stress that this is a global challenge that calls for ambitious political action by all states. In the view of the Nordic countries, the Paris Agreement provides a comprehensive and global framework for achieving our common goal. The objective of the agreement is to strengthen the global response to the threat of climate change through a combination of legal obligations and political targets. This particular regime establishes obligations and commitments for all parties, reflecting their capabilities and different national circumstances. The capacity of any state with regards to contributing towards our common responsibility is not static, and it may evolve over time as national circumstances change. We believe that possible obligations of states under other instruments and fields of law in respect of climate change must be addressed in careful consideration of the interrelationship with the United Nations climate change regime and the Paris Agreement. We recognise this Court's unique position to inform the understanding of the interplay between the various fields of law applicable to the protection of the climate system and the environment. The Nordic countries trust that the Court's forthcoming assessment and clarification of applicable international law will assist all states in identifying and advancing political decisions to further the global response to the threat of climate change. Mr. President, distinguished members of the Court, this concludes our intervention, and we thank the Court for its kind attention.
I thank the representatives of Denmark, Finland, Iceland, Norway and Sweden for their joint presentation. Before I invite the next delegation to take the floor, the Court will observe a break of 15 minutes. The hearing is suspended.